Hi, this is Business Law and Ethics, Chapter 4, Part 1, Workplace Law. So in this chapter, we specifically are going to look at detailed common law obligations of employers and employees and outline the purpose of various statutes impacting employment. So workplace law, Canadians have the right to be treated fairly in workplace, free from discrimination. That is our right. Laws and programs do protect this right, and unfortunately, a lot of employees don't take that in consideration when something happens to them. Not sure if they have the right or not. So it's really important that if you are an employee, you have to make sure you understand what are your laws and to protect you from discrimination. There's Canadian Labor Code, which is federal, regulated labor rights and responsibilities of employers and employees. The rights also of foreign workers in Canada are protected. So when you look at workplace law, it covers quite a broad certain acts and laws that goes under workplace law. Canadian human rights, contract law, employment standards, health and safety, equity, labor relation, and also tort law. So let's look at particular Canadian human rights. A law to prohibit discrimination in employment within federal jurisdiction. Canadians are protected from discrimination when they are employed under this act, and employers must ensure that all employees are treated equally. So this, no matter if you are a First Nations government or a federal government, private companies regulated, including banks, trucking companies, everybody under this has to be treated equally. Now, a question of what you're going to ask somewhere along the way, because I know you're a very curious bunch. How is an act different from a law? Well, there's not that much difference. An act is a single enacted bill, which is the beginning of the law, proposed in a single legislative session, approved in a single motion, be it federal or be it provincial. So the law itself can be the result of a few acts or multiple acts approved in many motions at different times, and which eventually will make it codified into a single statute. And a statute is the actual written law passed by the legislative body. So it works that way: act, law, and statute. Let's continue and let's look at what is employment specifically here in Canada. So employment involves one person doing work for another. An employee is said to be acting under the direction of the employer. So each relationship imposes different legal rights and obligations on the parties. Right? So this really is what is considered to be employment. Now, there's federal and provincial laws at a level. Government can pass employment-related statutes. So, and 90% of employees in Canada are certainly governed by provincial employment laws, right? So if you look at federal and provincial, it could be concurrent jurisdiction, which allows more than one court to have the authority to hear the same case. So the federal parliament has exclusive jurisdiction over employment, insurance benefits, and bankruptcy. Workers' compensation, though, is a provincial matter. So in Quebec, laws dealing with employment matters come with the jurisdiction of the local legislature, which is Quebec National Assembly. So the exception is the work undertaken under federal legislative power of the Parliament of Canada, which could be shipping, aeronautics, national railways, banking, all of this. Interprovincial CRTC falls under this, which basically takes care of, regulates television broadcasting and radio here in Canada. Here in Quebec, CNESST, it used to be the CNSST, it has changed. So it used to be just the CSST, I should say, I apologize, which used to be just health and security or work security. but right now, or labor standards. So this has been expanded a few years ago to include labor standards, pay equity, and also, as it was, occupational health and safety. So the CNSSC really is a sort of organization under, or a commission under, I should say, under the Quebec government that regulates all this and certainly reports to the Quebec government. Now, the importance of workplace law for businesses, it's just avoiding legal issues and applying legal risk management. So it reduces business risks and minimizes time-consuming and costly legal problems. Preserves business public image and reputation, and it also protects the business against far-reaching effects that possibly could happen. So it's very important, workplace law for businesses. Let's look at a definition of vicarious liability. A situation in which one party is held partly responsible for the unlawful acts of a third party. So, vicarious liability of an employer for torts committed by an employee in a course of employment. This is only imposed on the employer for conduct that is closely and materially connected to the risks created or introduced by the employer and during working hours. So if they operate trucks or vehicles, right, may cause vicarious liability to an employer. Certainly, if you are a truck driver and you back it up and you hit the where whoever you're backing up to, the shippers, receivers dock, and you hit the dock, and certainly you're responsible, but this is vicarious liability. So employer has a right to turn to employee for compensation when found vicarious liable. So that means that if they found that the driver, for whatever reason, was at fault other than actual work possibility, he can be charged or need to be compensated, or will have to compensate, I should say, the employer. Okay. Now here we're talking about hiring process. Certainly the hiring process is, honestly in good faith in the hiring process, employers and employees. If a nursery home hires a graduate, let's say a nurse, discovered that she didn't graduate, the employer is entitled to dismiss her, right? So this hiring process you need to go through a whole process of doing this before you actually offer a job and explain the actual process itself. So this can be misrepresentation if you certainly say you have a degree and you don't. You can get fired. And in some cases, depending on what it is that you do, you can be, legally responsible for sure. And another definition, this is when certain or all employees have to do their due diligence, right? So there is restrictive covenant, which is a clause in an employment contract that restricts the right or the legal right of employees to engage in certain type of activities during employment and after it ends, such as competing with the ex-employer, soliciting customers from the ex-employer, and disclosing confidential information about the ex-employer. So certainly if you write a contract, if you are in sales, or if you are a truck driver, or no matter where, if you walk into the plant and you see things, and then, or all about what's happening in one company, and then you go work for somebody else, and then you pass on all this information, this is called restrictive covenant, and you can't do this. Also, it's very important that if you are an employer, you do have to check references. A lot of companies do not do this, right? So the employer must keep in mind potential obligations related to checking employment references, although the law imposes no general obligations to check references. So an employer may nevertheless be liable for negligent hiring. Again, they will be responsible, not the actual employee who lied on their resume. Right? Of course, they can't fire them, right? But whomever hired them in HR or manager, they can also get fired if they don't do their due diligence and check references. If you look at contracts, it's very sticky subject when it comes to contracts, right? A contract of work and employment certainly doesn't have to be written. It can be oral or implied. You're hired. If someone says, hey, you're hired for next year, that's your contract. That's implied that you're working there for the next year. So the terms of employment agreement must be reduced to writing in order to be enforceable related to matters such as the length of the employment relationship. So if you say, hey, I'm going to hire you for a year, you're going to have to write it down, right? If I were you, or if I was the one getting hired, and you're telling me you're going to hire me for a year at such and such a salary, I do want it in writing. And also the obligations arising with the termination of the relationship. In other words, how can you get fired, right? This has to be certainly indicated in the contract. We talked about covenants before. So here's a question. Can my employer break my employment contract, and can I also break this contract? Well, it certainly depends on what the contract says. A contract is a contract is a contract. So neither you nor your employer can breach a contract without facing the consequences, depending on what it stipulates in the contract. If it says that they can do it, then certainly you can do it also. If it says that the contract can be broken at any time by either party, well then that's exactly what it says. But if it says that there has to be a time break or time period, has to be an assessment, has to be a warning, and all of this inside this contract, well, that's the way it has to follow, right? Says, so important that employees keep copies of these contracts and they're signed with their employers. So certainly you sign a contract, get a copy, but that is signed not only by you, but also by them. If you have a contract and they give you a copy, it's not signed by them, that's not a contract. There has to be two signatures and dated on the contract. Right, so on another subject, if you are a child working, there is an act for that, right? Labor Standards prohibits an employer for having a child to work that is certainly disproportionate to his abilities or that is likely to adversely affect his education, health, and development. That is common sense, and certainly age is 14 to work without the written consent. So when I was a little younger and I was 11 or 12 years old, I used to deliver newspapers, okay? But I couldn't get that job delivering newspapers without the consent of my parents. And in the consent, it has to be stipulated that I went to work I couldn't work before 6 o'clock or after 11. Okay, so that was really, this dates back a long time. So these laws, or this act has been around for a very long time. And if you talk about minimum wage, it used to be $12.50. And if you are an employee that works with tips, it's not minimum wage, it's a little bit less. Actually, this is something I just found out. I thought for sure it was exactly that because I was told and by certain employers that this was the case, but I found out that this is not true. So it is a little less. And also now it has just gone up to $13.10. So payments, if you look at payment, the wages must be paid at regular intervals of not over 16 days. At the time of each payment, the employer must remit a pay sheet or a pay stub. This could be done by email or by PDF, I should say, or an actual hard copy. Okay, but it does not have to be a hard copy. If you request a hard copy, they can certainly email, or they can actually send one to your home. And all deductions of your pay, right, is concerned about, it's pursuant to an act, a regulation, a collective agreement, or a decree, an obligatory supplemental pension plan, depending on what it is. You'll have all kinds of deductions from unemployment, certainly, and also to pay income tax, which is the act of the Income Tax Act. So every other deduction from wages must be accepted in writing by the employee. Insurance, right? If you have insurance from the employee, a lot of employees, the require that you go work, when you work there, that you have insurance. So if you don't want it, certainly there's a possibility, or I should say more than a possibility, they won't hire you, right? You have to have work insurance. So every other deduction like I said, from wages must be accepted in writing by the employee. Talking about waiters, tips, they cannot become part of the wages. They're a part, and the employer must pay the employee at least the minimum wage prescribed without considering the tips that she receives, like we saw before. And here, as it says, employer cannot require that an employee pay credit card costs. What that means is that if a lot of customers pay with credit cards, right, and they put the tip on the actual credit card itself, you cannot be charged for that in any way, shape, or form. You need to be given the full tip. And talking about working in restaurants specifically, or fast food chains, you will most cases have to have special clothing. So this must be provided and free of charge to the employee, which is paid at the minimum wage. It must not cause the employee to receive less than the minimum wage. An employer cannot require that an employee purchase clothing or accessories that are items in the employer's trade. Right. So if you decide that you want to have a logo of the company on a pad and you want to give that as a gift to a customer, let's say if you're working in sales, you certainly will not be the one that pays for that. This will go on your expense account and paid by the employer. So special clothing is very important when you're working in certain branches and certain chains. So clothing identifying the employee has been an employee of the establishment must be provided free of charge, like I mentioned, by the employer. So regular work week duration for the purposes of computing overtime, the regular work week is 40 hours. Certainly there are exceptions in, if you're a watchman is one thing. If you are working in different jobs where you might be isolated, it might be more. So there is a lot of exceptions when it comes to the actual work week. And speaking of work week, and if you are working, you're going to have coffee breaks and meals. So really the law stipulates that after a period of work of 5 consecutive hours, the employee is entitled to at least a 30-minute rest period without pay for meals. So a lot of companies offer an hour, and usually they'll pay half of it or not. So that is up to the discretion of the employee, that they will give you an hour. And if you sign a contract that it stipulates that you are not paid for lunch, then well, you're not paid for lunch. So a lot of cases that will be stipulated in your contract. And also, if she is not, if you as an employee are not authorized to leave your workstation, this period shall be remunerated for sure. So a coffee break in most cases is not mandatory, right? Whenever it is granted by the employer, it must be paid, included in the computation of the works of the hours worked, right? So they can't not pay you your coffee break. This is why they get very upset if they offer you a 10-minute coffee break. Well, then it's 10 minutes. If they offer you a smoke break, if you do smoke and it's 5 minutes, don't take half an hour, because that you're still getting paid. This is why a lot of employees are very careful with that kind of rule and regulation when it comes to smoking, and or are very attentive, I should say, also to employees that do smoke and take over 5 minutes to actually smoke a cigarette. And here's a few reasons to right to refuse work, right? More than 4 hours after regular daily work hours, more than 14 working hours per 24-hour period, and so on. So there's many regulations, as you can see here, if you can refuse to work. Again, if you accept, you accept. So certainly when you do that, you do have to work, and you can't change your mind, or you can change your mind later on, but if you do accept a work shift, you've got to be there. And certain exceptions to the right to refuse work, right? If the exercise of this right jeopardizes your life, certainly you can refuse. If you, in many cases here in Quebec, if you are pregnant, there are certain rules stipulated by the CNESST that are followed, that you can refuse to work. When there's a risk of destruction or serious deterioration of movable or immovable property, you can refuse to work. And if this refusal is inconsistent with the employee's professional code of ethics, right? We didn't really get into ethics. We will get into ethics. but ethics are very important at the work level, and certainly the employees' work ethics have to be respected, and if they're not, certainly if they are inconsistent, then this gives the employee the right to refuse work. Thank you. That is Chapter 4, Part 1.